Recording now. Hello, this is the meeting of the Discipline Subcommittee of the California Paraprofessional Program Working Group. We'd like to take roll now. Bashan?
Present.
Fellmeth?
Here.
Kirkmeyer?
Here.
Spiro?
Here.
Okay. And I don't see any attendees. I see 0 attendees, so it looks like we won't have any public comment.
All right.
Okay.
So Danny, thanks for joining us.
Hi, I'm sorry. I had this brilliant idea of trying to go outside and drive somewhere and get away from people on my day off, at which I'm sort of stuck in the middle of nowhere, but that's okay. It just took me a little bit to like find a place to just sit down and set up a hotspot. That's all.
Oh, okay. Well, we appreciate you doing this on your day off.
Sure. No, that part's the least of it. No, that's not a big deal at all.
Okay. So I think really this is an opportunity for the discipline subcommittee. I'm trying to remember, have you spoken to this subcommittee before, Danny? Or the
I think at least once. I think I gave an overview of the general sort of structure of what we have and like what we think the pros and cons are of our discipline system for the state bar.
Right. Okay. So where we're sort of going further into, I don't know about the weeds now, but getting more specifics about the parameters of a recommended paraprofessional discipline system. And at our last meeting, we really got a little bit stuck or realized we needed more information direct from the source about 2 issues that we're hoping you could speak to today. Alternative in lieu of discipline, so ALDs, how they work, how the process works, what they're used for. And then ADP, how do respondents get identified for that program and how does it work? At 12:15, Judge Roland is going to be joining us, and she is going to obviously be able to speak to the ADP program from her perspective. But if you could start off with both of those topics, and subcommittee members, please jump in if there's specific things you want Danny to start with, or just you can sort of let her proceed.
One question, the abbreviations, I remember what ALD is. I don't remember what ADP is.
The alternative. Go ahead, Danny.
So ALD is an agreement in lieu of discipline, and the ADP is the alternative discipline program. If you want to think in terms of, I guess in criminal terms, ADP is more like sort of misdemeanor diversion or some kind of deferred entry of judgment program. And an ALD is, it's closer, I guess it's closer to pre-plea diversion, if you would like to call it that. I don't know how familiar you are with criminal terms. So just generally, an agreement in lieu of discipline is something that we enter into with the respondent prior to charges being filed. And in some cases, it can actually happen after charges are filed. We can dismiss a case and proceed with an agreement in lieu of discipline. But basically, you know, what you're asking the respondent to do is to agree that they committed the misconduct, but for whatever various reasons, usually that either the conduct is low level or minor, or it's an extreme set of aberrational circumstances, and there's a lack of harm. You agreed that they will admit that they committed the misconduct, and they're subject to terms that are not unlike probation terms that you would have for discipline after a notice of disciplinary charges is filed. So I'm not saying it never happens, but we try not to have that in cases where there's harm to either the administration of justice or to a particular client. We just have them admit that they communicated with the represented party, or that they failed to, usually it's failed to perform competently and failed to communicate with their client. Those are sort of our bread and butter charges. And if there's no significant harm to the client, then we let them admit those charges, and then they're subject to our normal probation terms, which is, you know, quarterly reports, usually restitution, ethics class, client trust accounting school, and that sort of thing. Maybe the multi-state professional responsibility exam. But the benefit to them, so, you know, there's sort of 2 sides to the benefits for the alternative, for the agreements in lieu of discipline, which is the benefit to them is that it's not going to go on their record. It doesn't count as actual discipline. It's not public, so it's not going to go on their member profile page. But then the benefit to us as the state bar is they have to admit to culpability. This is not something that they can plead no contest to or that they can dispute later on. They have to say that, yes, they did fail to perform competently. They failed to communicate, they failed to pay restitution, whatever it is. And they have to stipulate to the underlying facts. So from the state bar side, we get the benefit of their agreeing to the underlying facts. So we no longer have to prove those, agreeing that they committed misconduct and subjecting them to the same sort of level of probation that they would have had post filing a notice of disciplinary charges. Now, if they complete their probation terms and they do everything right and they make no mistakes and they do they pay their restitution, they do all their quarterly reports, they take and pass all of their classes, then the case will never count against them as discipline ever. It basically vanishes into nowhere. And it's sort of a one-shot deal. You don't get that. You would never get more than one agreement in lieu of discipline, even if you were to complete it successfully. If you were to get in trouble again, we would not be inclined to extend that opportunity a second time. But if they don't complete their probation successfully, they don't fulfill all the terms of the agreement under the statute, that's actually a separate Business and Professions Code violation. So on the one hand, we've already got them to stipulate to everything. They've admitted the prior misconduct in the form of the failing to perform competently or failing to communicate, and they've admitted to the underlying facts. So we would never be subject to having to prove that again. And on top of that, they will be subject to a new disciplinary action for violating an agreement in lieu of discipline. I think it's 6068L off the top of my head. Basically at that point, they're on their second disciplinary case and we don't have to prove the first disciplinary case, and we would charge all of that sort of wrapped up into one. And then of course, all of that becomes public. So it really does provide a benefit to the state bar, and that we don't have to prove that culpability or those underlying facts again. And it provides a benefit to the respondent that if they do everything right, then they won't have a prior discipline. So it's actually a really beneficial program. I think the big policy questions that you have to decide are what cases can and cannot be eligible for an agreement in lieu of discipline. And I think obviously, depending upon, where your priority is, that kind of thing, it changes over time, but you have to set that out very early on, because otherwise, you're going to have people who commit serious misconduct who are going to say, I want my agreement in lieu of discipline. And you have to be able to tell them, per policy, you're not really eligible for that. So that's agreement in lieu of discipline. I don't see Judge Roland yet. The other program, the alternative.
Judge Roland is, I do see her.
Oh, you do? I can't see.
Yeah.
Hi, everyone, but feel free to go ahead.
Okay, hi.
I can start a little bit later.
Okay, well, Judge Roland, they were saying that maybe you would be talking more about the agreement and the alternative discipline program instead of the ALDs. I can speak to it briefly. Obviously, the alternative discipline program was started as an expansion on the statute that created the Lawyers Assistance Program. So we have a whole program under the statute called the Lawyers Assistance Program, which in and of itself, the LAP only provides sort of treatment, but the language of the statute I don't know how you'd say it. It speaks to the possibility of getting mitigation credit in your discipline cases if you participate in the LAP program. So, sort of born out of the creation of the LAP by statute was this separate creature called the Alternative Discipline Program, whereby people were able to enter an alternative track and use their participation in the LAP program to hopefully mitigate the outcome of their disciplinary program. We have, the way it's set up now is that you have two potential levels of discipline in the ADP. It's just easier to call it the ADP. One is a lower level of discipline should you successfully complete all of the conditions that are set forth in your LAP treatment program and anything else that you agree to with the judge. And then a higher level of discipline should you not successfully complete that treatment program. So the LAP is a creature of statute, and then the ADP was something that was generated because the statute sort of suggests that you should get mitigation credit for participating in LAP. And I can tell you, I mean, I have a little bit of sort of experience with ADP as it has evolved over time. In the beginning, when we first created that program, we had sort of that same problem that I suggested that you might run into with the ALDs, which is that everybody wants in. Everybody wants a chance to say that they have something, you know, that's created they've got some sort of mitigating circumstance in the form of mental health troubles or substance abuse troubles or that type of thing that should warrant a lower level of discipline and should warrant participation in the program. And early on, when we wrote the language of the ADP, we did not exclude serious misconduct. So we actually had some very serious misconduct that people had applied to and had gotten into the ADP program, and these were disbarment level cases, and you know, they were getting, you know, mitigation credit for participating in the ADP, and when they really shouldn't ever have been brought in the ADP in the first place. I think it was back in it was right around when I started with the bar. I got one of the first cases like that. And I'll just tell it to you because it's a little interesting and we'll give you an example. We had a public defender who had been accused of having sexual relations with in-custody clients. Now, putting the logistics of that aside, these are people who legally can't consent to sexual relations because they are in custody. And, you know, basically he was, you know, trading, you know, sex for better treatment and more work on these women's cases. And he had said that he had a problem and he got put into the ADP program, and they were looking at a low level of discipline at like 60 days. And, you know, as far as, you know, we were concerned, this was a disbarment case. And so we actually had to take that case all the way up to the California Supreme Court, and we were actually able to get him kicked out of the ADP program. But the problem was the way we had written the rules at the time, he was eligible and he had applied and the judge had let him in. So now, obviously, the rules and the eligibility criteria for the ADP program have been gone through several reiterations, and serious misconduct it's just not eligible for an ADP program. And I think that's, you know, more appropriate for something like an alternative discipline track. So I don't know if that's a good primer.
Well, let me just bring Judge Roland in because I think she has limited time.
Okay.
Judge Roland, remind us, are you available until 12:30 or?
Oh, I'm available until at least 12:45 or 1. I'm in trial,
Okay.
but I've taken, made the parties aware of the fact that I won't be returning right away. So everybody is fine with that. I'm good on time.
Great. So
Okay.
if you could, before, I know that subcommittee members are going to have lots of questions, but just speak to how the ADP program works from the court's perspective. I think that would be helpful before we launch into questions.
Okay, sounds good. First of all, my name is Judge Roland. I'm a hearing judge with the State Bar Court. I've been sitting on the State Bar Court bench since November of 2014. And I've handled a number of ADP matters from 2014 on. Each judge has an ADP docket. And I apologize if some of this is a bit repetitious in terms of what Ms. Lee has stated, but feel free to ask questions later. I've prepared this in a format so that I hope I'm hitting on the main questions, issues, or concerns that you might have. In order to understand ADP, though, I think you have to understand a bit about the State Bar Court, and I'm not sure what everyone's understanding is about the court. Then you'll understand why this is an important program in the court. It was first developed in 2002. The Alternative Discipline Program, which I will just refer to as ADP, was developed to assist attorneys who choose to participate in an alternative program because they identify as having either a substance abuse issue or a mental health issue. The State Bar Court, given its mission to protect the public, the courts in the profession, while fairly adjudicating matters before it, thought it was important to ensure that these individuals are given an opportunity to participate in a program such as ADP. Because the State Bar Court is the administrative arm of the trial court, is the trial court, administrative arm of the Supreme Court, the State Bar Court makes recommendations to the Supreme Court, as Ms. Lee mentioned, makes recommendations regarding ADP proceedings as well as all other types of proceedings. Trials and ADP matters are venued and are decided in the two courts that the State Bar Court has in California. That would be in San Francisco and in Los Angeles. So first of all, you probably asked just what is ADP? Basically, as far as the court's concerned, the goal of ADP is threefold. First of all, we want to see that any attorney who wants to take advantage of ADP is assisted in overcoming the mental health or substance abuse issue that impaired the attorney's ability to perform competently. Secondly, we want to ensure that that attorney is assisted in becoming a productive and effective member of the legal community again. And third, as our role implies, we want to ensure that a fair level of discipline is imposed on the attorney, and a level of discipline that will enable the attorney to, again, as I said before, resume his or her role in the profession. The ADP program with the State Bar Court has a number of stakeholders. Not only are the State Bar Court judges stakeholders in the program, but the Office of Chief Trial Counsel, the prosecutorial arm of the State Bar, is a stakeholder. The Lawyers Assistance Program, which we commonly refer to as LAP, as a stakeholder. We consider medical professionals, even though they do not report to the court, but they do provide information primarily to LAP. The medical professionals retained by the attorney can be of great assistance in helping the parties in connection with addressing ADP matters. We all closely monitor any attorney who asked to be referred to ADP. And I should point out that they are monitored through the referral period, then they're monitored into the evaluation period, which is separate and apart from the referral period. And those attorneys are monitored after they've been accepted into the ADP program. Usually the discipline, whether that is probation, actual, or state suspension, is imposed at upon the attorney's completion, either successful or non-successful completion of the program. Just so you know, the way the program is set up now, I think we have found that it has been, we've had a fair degree of success, and I think actually a great degree of success in that roughly 85% of the attorneys who start in ADP end up successfully completing the ADP program. And that's my general estimate, but based on the years that I've been involved with it, it's not based on data, but that's basically we've seen a great deal of success. The judges make clear to those individuals who seek referral to the ADP program that we set high expectations for them. However, we also make it known to those individuals that we believe that they can attain those the goals of the program and they can meet our expectations. And we do that by having meetings with the conferences, ADP conferences, with the attorney, with a member of the Office of Chief Trial Counsel who's been assigned as that particular attorney's prosecutor, and with the fact that sometimes the attorney will have an attorney representing him or her, and that individual will attend the meetings as well. We get reports from the Lawyers Assistance Program. Usually those reports are provided to us monthly. If we ask for them more frequently, we will get them more frequently. You might ask, so who's eligible to participate in ADP? Basically, any attorney who's been charged with misconduct and who demonstrates that he or she has a mental health issue or a substance abuse issue that caused or had a relationship with a nexus to that misconduct. Some of the most common forms of substance abuse that we see involve attorneys with prescription drug addictions or attorneys with alcoholism, issues with alcoholism. Those are quite common. As far as mental health issues are concerned, the most common mental health issues are generally depression, anxiety, and again, one of the key issues is whether or not that mental health issue or the substance abuse issue was present at the time that the attorney engaged in the misconduct. In order to determine that, we ask the attorney to provide a nexus statement, and most of the hearing judges who are also serve as ADP judges will also ask that a medical professional provide documentation that states, that draws the relationship or the nexus between the misconduct, whether it's a DUI, whether it is a domestic abuse. Actually, we do have a number of domestic abuse cases as well. But we ask for documentation from that medical professional that establishes that nexus or relationship. We have multiple sessions with the attorney to determine the attorney's willingness or commitment to go through the program. The attorney must stipulate or agree that he or she engaged in the misconduct that they're charged with engaging in, and they must again commit to wanting to resolve the substance abuse or mental health issue while participating in the program. The folks who, and they must be enrolled in the Lawyer's Assistance Program throughout the entire period of the LAP program. Who is not eligible to participate in ADP? As Ms. Lee mentioned, there has been, this has changed over time, but basically an attorney who admits to what we would consider to be disbarment level misconduct is not eligible to participate in ADP. Even if that conduct or misconduct, such as moral turpitude, such as commingling, such as when I say misappropriation, for example, taking the client's entrusted funds and using them for other purposes, those are all the types of misconduct that would result in an attorney not being allowed to participate in ADP. Sometimes we have, it's rare, but sometimes we do have a medical professional who states that an attorney will not benefit from, will not substantially benefit from being involved in the treatment program or in a treatment program. And so that attorney would not be eligible to participate. And then finally, an attorney who previously participated in ADP and was terminated for unsuccessfully participating in the program, or for even if someone successfully completed the program and they want to come back again, then that person's not allowed to participate in ADP. However, they could participate in the Lawyer's Assistance Program. I'm not sure whether Ms. Lee told you about the Lawyer's Assistance Program, but that is a program that any attorney can participate in, and it provides assistance to an attorney for a myriad of issues. And it can be any of these types of issues, the mental health, or it can be a substance abuse issue. The LAP program is central to the making ADP work, because it is the LAP program with their, we've discovered with very competent, effective psychologists and therapists who actually design the monitoring plan that is forms the framework for determining whether or not an attorney is complying with the requirements in order to help that attorney become rehabilitated, so to speak. And that monitoring plan is reevaluated from time to time, and the court's apprised of whether that's been, whether or not the nature of any changes to the program and whether or not the attorneys successfully complying with it. The monitoring plan, for example, will require, say an attorney has a problem with alcohol, and the monitoring plan will often require that the attorney participate in a abstinence program, abstinence-free or abstinence program for maybe 2 or 3 meetings a week, group meetings. And those are often AA meetings, although there are a few other programs that they could participate in. The LAP monitoring plan will also often include random testing and random drug testing, and the attorney is the one who actually foots the bill for the random drug testing. It will also often require that the attorney obtain a quarterly report from their medical professional, often a therapist or a psychiatrist or a psychologist, that gives an update as to how the attorney is doing based on that medical professional's observations. That information is provided to the court. It's usually provided to the Office of Chief Trial Counsel as well, but the court is able to use that information to effectively determine what's happening in terms of that attorney's progress or lack of progress. And it's also helpful in determining to what extent that attorney seems to be really committed to moving forward. One of the challenges that you face in a program such as ADP is the person who starts off, who really seems to be committed to complying with the program. And then the person kind of falls off the wagon and they go back and forth, or things happen in their lives. But for the most part, I think most judges, ADP judges, try to give the person an opportunity to pull it together and to comply with the program, even if at some point they find that they violate the terms of the monitoring plan. So that's one of the issues that you need to be aware of. Also thinking about what is the appropriate length of time for a program such as an ADP program. The ADP program is intended to last 36 months. And that is really usually the maximum length of time for ADP in an attorney's ADP participation. However, if the attorney shows that he or she is doing very well, then the judge can reduce that period of enrollment in the program down as to a period as low as 18 months. And most of the ADP judges, we just kind of watch how things are going along, and we do dangle the early graduation as a carrot, and it's usually a very effective one. Before completion of the program, however, an attorney who has to provide a certificate that he or she has been substance-free for at least a year. And if it's an attorney who has a mental health issue, that attorney must provide a certificate from a mental health professional that recommends that the attorney be considered for graduation because the attorney has established that he or she's overcome the mental health issue. So what? Oh, sure.
No, I just wanted to make sure to give, because I know our subcommittee members have a lot of questions.
Oh, okay.
So are you okay to taking questions now?
Oh, sure.
Or taking it sequentially all the way through? I wasn't.
Oh, well, I can take questions now.
Okay. All right. So just because I see. So I think Julie, you had a question or two.
I did. Excuse me. This is Julie Fellmeth.
Hi, Julie.
I had a question for Danny. An ALD, you said an agreement in lieu of discipline is not Even if it's, okay, you said that it can be entered into after the filing of a notice of an NDC, right?
That is very rare, but yes, we have done that on occasion.
Okay. Is that NDC posted on the bar's website?
So what would happen, like the logistics of that is the NDC gets posted, charges are filed, and I would presume, obviously, I know it happens. I've never done it. But you go to a settlement conference, you're able to come to an arrangement, and the respondent is able to convince you that an agreement in lieu of discipline is the appropriate outcome. So the charges are then dismissed, and then the agreement in lieu of discipline is confidential. So it basically disappears off of your profile, and it certainly isn't a prior for you anymore. So, but that is it's kind of like a unicorn. I know it's happened, but it's not something that would happen very often, and there would have to be very compelling circumstances. And usually it involves, input from a settlement judge that suggests that maybe this is the appropriate outcome, or more information that you may not have necessarily had before you filed charges.
Okay. I had a follow-up question that is now gone from my brain. By the way, thank you both for your presentations. Judge Roland, you were talking about who is eligible and who is not eligible. And in both discussions, you said an attorney who's been charged with misconduct. Does that mean an NDC has been filed?
Yes.
Okay. And so if the attorney convinces you and or the Office of Chief Trial Counsel that the misconduct has been due to substance abuse or mental health, does the same process apply, i.e. the charges are dismissed? The attorney, if the attorney can convince you that they belong in the ADP and the LAP program, does that appear on the bar's website?
It does. Actually, that was the last point I was going to make. I'll touch that quickly. That's okay. An attorney who wants to be considered for ADP has to convince the ADP judge that he or she is should be referred to ADP and should be allowed to be evaluated by the hearing judge, the ADP judge. Your question is a good one with regard to what is public and what isn't public. The fact that an attorney is enrolled in ADP, and I think this is will likely be a key issue for all of you. I think I personally have some concerns about this, but I think that it's something that from the ground level you can address. The fact that an attorney is enrolled in ADP is public. It can be public. Any pleadings filed in the ADP proceeding, including the stipulation as to facts, which is the stipulation that the attorney engaged in the misconduct, that is public, unless it contains information that is so sensitive that a party will seek to have the judge seal the documents. That can be done. It's not done very often. What is private is any information about the nature and extent of the attorney's treatment. That is kept private. The LAP reports, the reports that the Lawyers Assistance Program provides to the judge and to the Office of Chief Trial Counsel, that is confidential, as well as any statements about the attorney's compliance with LAP. When the entire proceeding is concluded, if the request is made and the judge determines it's appropriate, then the file can be sealed. But that is fairly rare unless there is some highly confidential information in there.
So if I were to go onto the bar's website and I was searching the record of an attorney who's in the ADP and is in LAP, I would be told that they are in the ADP program, but not why.
You would be told they were in the ADP program. You would not be told why, if why includes an analysis of the treatment for that attorney.
So I wouldn't be told substance abuse versus mental health.
Not if the treatment is, it could reflect that the person was it's not always there. It could just reflect that the attorney was referred to ADP. And the order may or may not reflect why. There would have already been a discussion, but the ADP judges do not always include the reason in the order that we know is going to be public.
Okay. And one last question for you, Judge.
I mean, the goal is not to shame the attorney. The goal is not to punish the attorney. The goal is to get the attorney back on track. And while the discipline is an important part of it, the goal, what makes this alternative is that while the attorney is, you're attempting to get the attorney back in a position where the attorney can be a productive member of the legal community again.
Sure. You were talking about the kinds of conditions that would make an attorney eligible for possible participation in ADP and LAP. And you mentioned substance abuse and mental health. I think you also mentioned domestic abuse cases. Is that doesn't seem like it falls in the same category.
Well, what I'm saying is that sometimes we will have an attorney who will contend that he or she, that the misconduct, which, for example, is a conviction for domestic abuse, okay, that the misconduct arose from stress, from anxiety, from pressures, from alcoholism. But we're seeing more of those types of cases based on the statement that the underlying cause was a mental health condition. Sometimes we have attorneys who are suffering from a bipolar condition, from schizophrenia. Those are other examples of mental health conditions that we have considered and have allowed individuals, based on confirmation of that diagnosis, have allowed them to participate in ADP.
Thank you. I know you have limited time, so I'll let other people ask questions.
Yeah, Kim and then Ira.
Hi, Judge Roland and Danny. Thank you so much for your presentations. Just real quick, I'll ask Judge Roland, I'll go to yours for question first, just for time. You talked about individuals, if they do have that other conviction, are they also on like a probationary term, or once it's decision is they're going to go into the ADP program, that's all they have to do? There's not other coursework or other rehabilitation efforts that they have to go through, or is it, and if they do, are they separate paths, or does it all fit under the ADP?
That's a good question. Generally, when an attorney, after an attorney has been referred to ADP and the ADP judge is evaluating whether or not the person should be in the program, the underlying case, the conviction or the alleged misconduct, which the attorney stipulated to, that case is basically abated while the attorney is while the attorney is enrolled in the ADP program.
So let's say it was this conviction case. So they'll never have any action on the conviction case. It's just really, the decision's been made that this was all based on a substance abuse or mental illness. And so therefore, if they complete that successfully, then that other issue is just kind of let go at the end of completion?
No, it's not let go.
Okay.
The discipline, for example, let's use your example of the conviction case. Say an attorney is convicted for a DUI. What usually happens is that DUI goes to the report of that DUI. When it's reported to the Office of Chief Trial Counsel, will go to the review department in the State Bar Court. The review department will look at it to determine whether or not that conviction should be transmitted to the hearing department for a trial to determine whether there was other misconduct or whether the conviction involved moral turpitude. After the conviction is transmitted to the hearing department, if the attorney with the DUI says, I have a problem with alcohol, I'm an alcoholic and I would like to be considered for the ADP program, then that, what we call the standard proceedings, that original conviction case in the hearing department would be abated until the evaluation determination is made with the ADP. With whether or not the attorney should be a participant in the ADP program. After, say that attorney goes through the entire ADP program and successfully completes the ADP program, the level of discipline that would have been discussed, usually at least a year or so earlier, discussed between the judge, the Office of Chief Trial Counsel, the attorney, and if the attorney successfully completes, then the low level of discipline that's already been agreed upon would be imposed on the attorney with the completion of ADP. So for example, if in that case, the decision would have been made that the attorney should have a one-year state suspension where the attorney can practice law, but for that 1 year, the attorney has to submit quarterly reports. And the attorney has to report to the probation representative from the Office of Probation, then that discipline would be imposed after the attorney completes the program. If the attorney has a 30-day actual suspension, unless the judge determines that that actual suspension must take place at the time early on, then that suspension could be imposed at the end of the successful completion of the program. It can be done either way. But the bottom line is the conviction, any hearing or trial for the conviction would not go forward, but the case doesn't go away. The discipline, I'm not sure if that's clear, the discipline would still be imposed after the attorney completes the program.
Okay, so same thing if it was a misconduct that they did when they were with one of their clients, but they also had this issue of substance or mental illness, and it was found to have caused that, they'd still go into the program, but at the end, there'd still be an outcome on that other type of misconduct as well.
Well, there must be, in order for someone to be eligible for the ADP program, they must have a problem or an issue that falls squarely within a mental health problem, mental health challenge, or a substance abuse challenge. If someone says, I have anger management issues, but the medical professional says, well, that's not, as far as we're concerned, that's not a mental health issue, then that person's not eligible. If someone simply says, I was experiencing financial hardship, and so I took my client's money, I misappropriated the funds, that's not a mental health issue. That's a financial hardship, but it's not a mental health issue. That person would not be eligible for ADP. So they have to, whatever the misconduct must be attributed to either a mental health issue or a substance abuse issue.
And what if they had both? What if they have a mental illness or a substance abuse, and it came in with the same time with the complaint of the misconduct?
The mental health and substance abuse, there can be an overlap.
Okay.
If that is the case and they want to be considered or be evaluated for ADP, then that's definitely possible.
Okay. I have other questions for Danny, Leah, but do you want me to wait until Ira gets a chance to ask questions?
Yeah,
Okay.
maybe if Ira has questions for Judge Roland, just because we're past 12:45 now. So I want to be respectful of Judge Roland's time. Ira or anybody else. Sharon has her hand up. But Ira, did you have anything?
Yeah, I do. Judge Roland, as far as who's eligible for ADP, I thought I heard you say that a lawyer who admits to a violation that could result in disbarment is not eligible.
That's correct.
But do they have to admit it, or is it a matter of what's charged?
No, it's a matter of what's admitted. What the attorney, in other words, any attorney who wants to participate in the ADP program must admit that he or she engaged in the misconduct. That's the first thing, because that's the first step in moving in the right direction to say, well, yes, I did engage in misconduct, and then to acknowledge what caused that misconduct.
So
So if you start off by saying, no, I didn't do anything wrong, then you don't need the program.
no, what I mean is this: if what the charges are filed and then it's known what the lawyer would have to admit to in order to be an ADP. If what they'd have to admit to could result in disbarment, then they're not eligible. Is that right?
Well, that's right to a certain extent. Often the Office of Chief Trial Counsel will engage in discussions with the attorney as to, by sharing the information that the Office of Chief Trial Counsel has that leads that office to believe that the attorney is engaged in that misconduct. The court doesn't determine whether or not the attorney engaged in the misconduct. It's really a discussion, and Ms. Lee can elaborate on that if she wants to, is really a discussion between the prosecutor and the attorney. And it's not uncommon to see a notice of disciplinary charges that alleges that the attorney did certain things, and then the stipulation that's submitted in ADP is not as rigid as the as the original NDC, because maybe the attorney was able to say, this is what I actually did. Here's some documentation that reflects what I did and why I did it, or whatever. But that's a discussion that does not take place with the court. The court looks at the stipulation after it's been entered into by the parties.
I see. All right. On a different note, maybe you don't want to answer this one, but you expressed what I thought is something like reservations about about one of these things being public.
Publicity.
Can you tell us what your reservations are?
Well, I think that one of the challenges is, we all know this is a very competitive profession. And when folks look on a website and they see a statement about an attorney and they don't have full context, an attorney might find that his or her practice is severely impacted by what's reflected on that website. And so the fact that a person participates, I have to say, though, it doesn't appear that attorneys who acknowledge that they have mental health or substance abuse problems often do not turn away from ADP because of the fact that they participated in ADP is going to be publicized. But I'm wondering if to some extent it isn't a deterrent for some who would otherwise participate. And so I think that at some point we have to really revisit whether and to what extent, and you're in a position to take a look at that at the outset, to what extent should the full scope of an individual's participation in a program that's intended to help them become rehabilitated, to what extent should that be disclosed? There are competing arguments there. There's also the argument that members of the public are entitled to know about an attorney's prior professional history. And professional history, yes, but that's it's an issue to be addressed, certainly, and probably better for you to take it on earlier rather than later.
Thanks.
Sharon, and I don't know, did you have a question for Judge Roland, Sharon?
I do, thanks. So Judge Roland, I'm wondering if you keep stats on how many participants who successfully complete the program later re-engage in misconduct.
That's a good question. I'm going to go back and toss that to Leah, because I think at one point we talked about compiling those stats, and I don't recall off the top of my head whether or not that was done. I feel that there's a very low percentage, but I don't know.
We do. At least when I was at the bar, we did pull together recidivism data for all different types of proceedings. I don't know when it was last updated, but that's certainly something we can check on and provide Sharon. And if it hasn't been updated, at least the data from a couple of years ago.
Yeah, I was just curious. And then also, like, if
One thing I would suggest, if you're going to look at that, look at the data as it relates to recidivism among those folks who participated in and successfully completed ADP and those who did not, so that you are comparing, you know, kind of apples to apples. Go ahead. I'm sorry. What were you going to say?
yeah, no, that makes sense. So it sounds like this program is meant to be like one bite at the apple. Like what does happen? Because we're talking about serious issues, and someone can relapse and then you know, reoffend. How are those cases treated? They're not diverted, but do they just go through the regular disciplinary channels through the bar at that
If
point?
someone, yes, if someone does engage in future misconduct, then that case would be filed and we would proceed with the proceeding. Sometimes I have had folks come back and ask if they can participate in ADP again, and you know, the answer is no. It's pretty clear.
I'm also wondering how many of these cases that involve mental health or substance abuse also have a fact pattern of fraud on the client.
Well, we wouldn't allow a case that involves fraud. We wouldn't allow that person to become a participant in ADP. And although it's interesting you said that, I just had somebody about last week who acknowledged the fraud and still wanted to participate in ADP, and the answer is no. I think that there's a fairly low percentage of cases where an attorney is engaged in some form of fraudulent misconduct where they actually seek ADP participation.
Thank you. That's very helpful.
You're welcome.
Judge Roland, it's 12:56. Do you?
Okay. Yes, I should leave. Thank you for inviting me. I'd be happy to come back if you have other questions or you'd like to discuss this a bit more.
Thank you so much for your time.
Thank you, and good luck.
All right, so we still have Danny on, and I think we probably have more questions to ask about the ALD as well as the ADP.
I have questions, Leah. It's Kim.
Go ahead, Kim.
So Danny, just a couple questions on the actual, first of all, to get an ALD, is that what it is, ALD? To get the ALD, do you only go to that level of discussion if it's regarding substance abuse or mental illness?
No, actually, that's not, the ALDs are not limited by the same types of parameters that the ADP is. An ALD certainly isn't necessarily limited to those types of things. An ALD is for anything that's low-level discipline and that appears to be really aberrational. You know, you can failure to perform and failure to communicate. If this is something that you've never seen before, an attorney, and the attorney may not have been going through, you know, any particular problems. They just dropped the ball on one case, and they dropped the ball to a level where the state bar had to become involved. But if you're not seeing any other problems and they've never been in trouble before, they certainly don't have to come to us and say, you know, hey, I was having some mental health problems or I was having a substance abuse problems in order to be eligible for ALD. It's just, this appears to be a one-off. There weren't a lot of people hurt, and it's something that, you know, based on what the evidence that they're giving to us is really aberrational and low level, such that they deserve the opportunity to enter into this agreement and not have a prior discipline.
So really, who makes that decision? I'm sorry, maybe I missed this. Who makes that final decision for that person to go into the ALD?
I mean, and obviously, you know, it's the Office of Chief Trial Counsel. We have to extend the offer. They can't say, you know, I send them a letter saying I'm going to file disciplinary charges, and they say, hey, I want an ALD. If we don't extend the offer, they may be able to ask for it, but if we don't agree to it, they wouldn't be allowed to do that. And obviously, you know, my department has a whole, you know, internal policy and hierarchy as to what cases can and can't go in there, and what cases would and would not require, higher level approval in order to extend that offer.
So that was going to be my next question, is what is that process? How do you make sure that it's fair and consistent as far as, who gets to get this, I mean, for lack of a better word, like a freebie, almost a free pass on one of their, potential disciplinary actions, what gets one person that and another person not. So you do have some set standards, it sounds like, that you have to go through.
Yes, we obviously have set standards, and I think my department is fairly well known for the fact that we have lots of extensive policies and procedures. So they try very hard to strive for uniformity. And I don't think it's a secret. I, as a senior trial counsel or deputy trial counsel, everything I do is run by my supervising attorney, and if it's a major case, it's got to be run through the chief. So I'm not unilaterally sitting here making the decision to hand out those sort of things without approval of senior staff and supervisors and managers. What I decide to do in a case is subject to review by my immediate supervisors and by my management. And again, there are certain cases that just plain aren't eligible. And then in addition to that, I have to get approval on this. So.
Okay, that's really helpful.
I have a question.
Yeah, go ahead.
First a comment. It's kind of unfortunate that these acronyms are so similar, the ADPs and the ADPs, and I think some of us might be confusing them, or the two programs, which are different and have different purposes. Danny, do you know the statutory citation to the section of the State Bar Act that allows ALDs, agreements in lieu of discipline?
So if you look at, I think it's, again, off the top of my head, 6068L, what that says is, and there's a lot of 6068, so it might be an I. I know I is failure to cooperate and J is discipline. So I'm pretty sure it's 6068L. What that portion of the Business and Professions Code says is it's misconduct to violate an agreement in lieu of discipline. So that sort of presupposes they exist. Off the top of my head, I'm not really sure where it says anywhere else in statute that we are allowed to do ALDs, but then separately, the Office of Chief Trial Counsel has its own internal policies that allow for the creation of agreements in lieu of discipline. And I think it was just sort of presupposed when they wrote that into the statute that if you violated it, it was misconduct, that we were allowed to do such things. Past that, you'd have to look back at board policy, and I don't know that off the top of my head.
I can just
And
add
you also talked about the rules that used to allow disbarment level misconduct to qualify for an ALD, and that you mentioned that those rules have now been changed. Do you have a citation to those rules?
It's our State Bar Rules of Procedure. All you have to do is go to the section for alternative discipline programs. They have the case that I mentioned to you was a case that occurred, I think it was in 2007. Because it was right when I first started at the State Bar. I was in the Office of General Counsel, and I think you've heard a lot from Judge Roland about how there's interaction with the Office of Chief Trial Counsel along the way. And the early rules were just not set up with that level of discipline. We weren't allowed the opportunity to see the nexus statement. We weren't allowed the opportunity to object. It was a very new program. They were trying really hard to implement it. And in the process, I think a lot of details got left out. So that was back in 2007 and 2008. And we've gone through many iterations of the rules of procedure since then. So I think if you look at, the State Bar Rules of Procedure and the specific section for the ADP now, you will see a lot more detail and a lot more structure than, whatever we had way back then.
Okay, thank you.
Greg, were you going to say something?
Yeah, another source of requirement to comply with agreements in lieu of discipline are the Rules of Professional Conduct, Rule 8.1.1. And that refers to provisions of the State Bar Act as well, 77 and 78, which imposes discipline for failure to comply with the rules of Professional Conduct, as well as Rule of Court Rule 9.19, which governs conditions attached to reprovals.
So reprovals are a little different than an ALD, and I thought I misunderstood. Unless I misunderstood, the question was what gives us the authority to even create an ALD? Was that
Yeah.
I thought that's yeah, and that's what I don't know off the top of my head.
Oh, okay.
I just know that the 6068L presumes the fact that we are allowed to have them because we can find them guilty of misconduct for having failed to comply with them.
And 6068K to comply, it says to comply with all conditions attached to any disciplinary probation. So would that be considered an agreement in lieu of discipline? Would that be considered a disciplinary probation?
No, that's why we have a separate section L, because agreements in lieu of discipline are not considered discipline. So K would be for, probation violation, and then L is to if you violate an ALD specifically.
So Kim, can I ask a question? Because what you've told us on the DCA side, or at least the medical board side, well, first of all, is the program as being described, the ALD, is that diversion in the way that that term is used on the DCA side?
No, because for us, diversion solely is, and this gets so confused with individuals. I'm trying to deal with this right now. Diversion is not a monitoring program. Diversion, to me and my thinking and how it was always applied, diversion are individuals that have a substance abuse or mental illness that they come to the attention of the board. And once they are brought to the attention of the board, they find out they have this issue. They're diverted out of the enforcement process into a drug or alcohol monitoring program. So to us, that's the word for diversion. But it's used also, we have our other boards and bureaus that use it for a program where an individual can also come in and go into this diversion program. But to me, that's not diversion. But our thinking more is you've diverted from the enforcement process. Julie, you agree kind of with that, right?
Yeah, I do. The agreement in lieu of discipline that the bar has been implementing for many years really sounds to me more like the citation and fine process that the DCA boards have that you don't, Leah. It's for low-level violations, which are violations nonetheless and probably should not be ignored. But as Kim said, because they're not public, subject to their completion of all the conditions that are placed on them, it's kind of a freebie. So we're all depending on you to make sure this is a one-off, an aberration, something that this person does not do as a business practice. But it's the agreement in lieu of discipline sounds a little bit like citation and fine, only less structured, although I haven't looked at all the rules that surround the ALDs.
Less structured. I was going to say it sounded more structured than citation and fine, because I thought citation and fine, you just got a citation with a fine, and then you have to pay it, not you have to submit reports and take this class and that class.
Well, a citation and fine is not, Kim, correct me if I'm wrong, it's not considered discipline.
No.
And it's not considered probation.
No.
It's just a citation, which is like a ticket, could include a cease and desist order, or what Kim was describing at the last meeting as an abatement order. Stop it. If, like, for example, you're doing false advertising. And it can include a fine up to $5,000 per violation. But there's a lot in Business and Professions Code section 125.9, there just are a lot of bureaucratic requirements that each individual DCA board has to go through if they want to establish a citation and fine system. And I don't think the bar has those bureaucratic requirements.
That sounds to me more like the equivalent of a warning letter for us. We obviously, there's no fine involved with a warning letter, but if it's really that low level and we really don't think, and honestly, warning letters are for cases where we honestly think that if we would go to court and try to get them disciplined, that we would lose. So instead, we just simply issue them a warning letter. We say, we think that you communicated it with the representative party in the future. Please don't do that again. And they get a warning letter, and that's it. Because if I were to try to bring that case to state bar court, I would get nothing on it. So that's more like a warning letter. The agreements in lieu of discipline are much more involved. They have conditions that parallel probation. Where they've got quarterly reports, they've got to take ethics school, they've got to take client trust accounting school, they've got to take the multi-state professional responsibility exam. So what they have to go through for the ALD is much more involved for them to get the benefit of not having a prior discipline.
Citations and fines are public.
Yes.
Well, so an ALD and warning letters are not.
Yeah, and ALDs almost, Leah, from my perspective, almost sound like our old school kind of when we did like an enforcement agreement. It seems like it's a little bit higher level than our citation and fine potentially, because our citation and fine really are, well, at least for medical board. Let me speak for medical board because I can't speak for all the others because I just don't know them well enough. But for medical board, they were more really very, very low level as to where the level that it sounds like for you all with your ALDs, it almost sounds like those are at the level where we would issue like a public letter of reprimand with some type of course. And it sounds like the bar has this kind of middle ground where it would be discipline, but they're doing this agreement in lieu of discipline.
Mm-hmm. Okay. And if we were going to add citations and fines to our, panoply of available interventions or outcomes, would it be a warning letter with a fine? Would it be an ALD that would include a fine component and maybe fewer monitoring terms? Meaning, mostly what you need to do is pay this fine as the condition of your ALD. I'm just trying to think about the sort of the articulation of the various potential outcomes or responses by the state bar.
Are you just talking about the paraprofessional program now?
Yeah. Yeah, because we don't have citation and fine on the attorney side. Just thinking about, because you all have been, I don't know if you're going to want to have an ALD version on the paraprofessional side, but we've talked about having an ALD type of option, citation and fine, and then we've talked about diversion. So just trying to get clear on what we mean by all of these and sort of the gradation of them in terms of level of severity.
Sorry, Greg, go ahead.
That's okay. I think it's also important to understand, I think a warning letter and an ALD that is successfully completed is not considered discipline. And we do have a progressive discipline scheme under our standards. And so any lawyer who successfully completes an ALD or has received a warning letter and then later engages in additional misconduct, that prior warning letter or successful ALD is not considered an aggravating circumstance in determining the level of discipline. Do I have that right, Danny? I think that's correct.
Yes, that's correct. But it certainly will inform us if, they come back, even if it's 5-10 years later, if they come back and they're saying that this is aberrational behavior or that, the respondent is no longer going to get the benefit of the doubt if they got the benefit of the doubt. And just off the top of my head, the most recent example in my recent memory I can't say much more than that, is in the case of DA misconduct. If you think this is an aberrational behavior, they may get that from me once, but they'll never get that from me again. That's for sure.
I have a question about that, Danny. How long does the record of an ALD stay in the state bar's records and not get purged from them?
Well, the state bar keeps everything forever. At least my department does. I can tell you that after the recent study regarding racial disparity, we're not supposed to look at complaints that are older than 5 years. And that's just complaints. That's not even complaints that resulted in discipline. So I I would imagine that, and that this is not my stating what OCTC's new policy is based on that recent study. But if we're not looking at complaints older than 5 years, I can't imagine we would be looking at ALDs older than 5 years, other than ALDs have obviously moved farther along the spectrum than just a random complaint being filed against you. So, we keep everything, forever.
So if I did a Public Records Act request on an attorney for any ALDs in their past, what would I get?
They're confidential. So, and they're not disciplines. Any disciplinary investigation that does not result in discipline pursuant to statute is confidential.
I have a question for everybody here. Couldn't we have for the paraprofessionals an ALD system that could include something discipline? One of the types of discipline that it could result in is something as minor as a fine. As a fine. You go all the way up from that to other higher levels of discipline, and the conditions also could be payment of the fine, something as simple as that, or many other conditions. I'm just throwing out ideas. I'm trying to think what we might do for the paraprofessionals.
I think that's what I was kind of asking Ira. Just if you're going to keep the ALD concept, could you incorporate citations and fines in that paradigm, as opposed to creating like a separate citation and fine process?
Right. Is there any reason we could not do that?
The citation and fine would be confidential then, because if it's part of the ALD.
Yeah.
I think that gets a little muddy from my opinion, to keep them confidential, especially when there's money involved with it.
I mean, it seems like a citation and fine would more appropriately be attached to a approval than an ALD or a warning letter.
Yeah, I guess the overall question, and to your question about warning letter with a citation and fine, Leah, I don't think you need both. I think you could have both as part of your process. Like there's something here that we can't prove beyond, whatever the citation is, beyond a reasonable doubt. No, what is it?
Clear and convincing.
Clear and convincing, right? But what's the lower preponderance? Sorry, I couldn't think of preponderance. So it's not preponderance like cite and fine, and it's definitely not clear and convincing, but it's something that we think happened. This individual did wrong. I want to send them a warning letter. And then there's the citation and fine, where it's a lower level. It's not anything you want to take discipline on. It's one item, because sometimes you have lower level things that you'd issue a citation and fine for, that if it was added on with some other things, it would be discipline. But it's this one avenue, and it's a citation and fine I'm going to issue. And then I think the piece where I'm uncomfortable, but want more discussion, is on this ALD piece. And then you have full on discipline. I think those are kind of the steps we have. But can I go back on the diversion question just real quick? And maybe Danny, you can answer this, even though Judge Roland isn't here, on that ADP part. So if I'm a substance abusing attorney and I come in to the program, they said that NDC, ADP is always after NDC is filed. Is that what the judge, I want to make sure I was clear on that.
Yes, that the alternative discipline program, you are already in the discipline system. Something has been filed against you. A conviction has been transmitted and has been sent down to the hearing department, or we have filed charges. You don't get into ADP before charges are filed.
So there's no way that for me to go into a substance monitoring program without discipline. Is that correct?
Sure, there is. That's the LAP. That's the Lawyer Assistance Program. Anybody who wants to go get treatment, whether they're having a discipline problem or not, can go get treatment as long as they participate in the program and pay for it. The LAP is a creature of statute. I can't remember the number off the top of my head. But the alternative discipline program it's a discipline track, and basically, you know, I think just to follow up on what Judge Roland says, charges have been filed against you, and what you're saying is, wait a minute, I have a problem, and I'm standing here before you saying I want to address that problem, and while you do that, your disciplinary case it's not abated, but it is, you know, the only thing that's going on when you're an ADP is you are, as the lawyer, you are getting treatment, right? We're not looking at your normal probation conditions. We're not really looking at your suspension, although you, like she said, you can do that at the same time. But you're going to go through this period where the court is going to watch you while you go through treatment. And then at the end of the treatment, then we're going to go ahead and wrap up your discipline case. And that's when we're going to decide to give you 18 months suspension instead of 2 years suspension, or you're going to get 90 days instead of 18 months. But then, you know, when you're all treated and you're all better and you're ready to conclude your discipline case, then we're going to subject you to your normal disciplinary conditions, which is probation, which is quarterly reports, which is, you know, client trust accounting school, ethics school, and the MPRE, all of those types of things, unless it's a case where you're going all the way down to a reproval, or even reprovals have conditions. So there's, to my knowledge, there does not exist an ADP outcome where you come out with it with a dismissal. That just does not happen. So you're going to have your discipline case at the end, but while you are participating in ADP, it's focusing on your treatment and putting you back together so you can go out there and practice in the world. But you're still going to face the consequences of the charges that we already filed against you at the end of that period.
So it's not a diversion program.
And those charges are public information posted on the bar's website, right?
Sure. Yeah. I mean, I only got one case in ADP right now, but since you guys were asking questions about it, I went and double checked. It's a conviction case. So you can, if you go and you look up his member profile, you can see that a conviction case was transmitted against him. And then if you take that case number and you put it in the state bar court, you can go see that there are, like, you know, status hearings, but that's all you really see. There's nothing else that you can see on there right now. You'll see it at the end when he's done with his ADP program. But the fact that there was a conviction transmittal and that there is a pending case has not been taken away from the website or the court's website.
Does that answer? I think, Kim, you asked that question.
Yeah, it sounds like, and maybe this goes to the fact that you guys aren't notified of a substance abusing attorney, with that being the only fact coming in, you know, and that's where we differ probably from DCA side potentially, because it sounds like you don't have any case where it comes in and that really is the only issue that they have.
No, we don't mandate people going into the LAP. We do sometimes get complaints like that where people will say, you know, I know this lawyer, he's an alcoholic, he's got real problems, I think he's falling apart. I think we do, as a courtesy, send an LAP letter to them, but we certainly don't force them into the program.
Would you investigate it though to decide if it's impacting the quality of their work product? Their standard of care?
No, we need concrete, identifiable misconduct allegations to investigate, because otherwise, you know, we're placed in the position of just sort of trolling around in people's, you know, lives without, you know, identifiable allegations of misconduct. We don't do that. If it's the person is an alcoholic and they failed to appear at trial, I will investigate failed to appear at trial. But the person is an alcoholic and they're kind of dropping the ball without any specific cases or clients to work on. The most that we're going to do is send them a letter telling them they can participate in LAP if they need to.
So Danny, can I just follow up on that? Because if the failed to appear, so they failed to appear and you're going to investigate that. What if it comes back and you find out that failed to appear is solely for a substance abuse issue? How would you handle that case?
It's okay. So the classic scenario is I've lost contact with my attorney and then they failed to appear at trial and I lost my case. So I'm at the misconduct allegations that I'm looking at there are failure to communicate, failure to perform competently, and improper withdrawal or abandonment, and potentially failure to return unearned fees, depending upon whether or not they were paid in advance. I'm going to treat that as a normal case. Even if somebody has told me somewhere along the line that they think the guy is an alcoholic, that the fact is they have there's identifiable allegations of misconduct. I'm going to go forward and I'm going to prosecute. It's up to them to bring me information to show that, you know, there's mitigation, and I'll say that's all very well, nice and good, but I'm going to file charges against you, and then you can ask for participation in the ADP program. Because if we have a case where, you know, you've got client harm, you've got, you know, the minute orders that show that they didn't show up to trial, the client lost the case, the $5,000 retainer is gone, and there's no work to show for it, that's a prosecutable case, and I'm going to prosecute it.
Danny, can you just explain, if an attorney's accepted into ADP, what happens to their ability to continue practicing while they're in ADP?
So there's a temporal sort of distinction there. Like, I think with the concern that you're sort of articulating is that, are they presently an alcoholic? Are they presently falling apart? Is their current practice a disaster? And the only way that we can really judge that is by the number of complaints that are sort of filed against and how many cases that we're triaging for a particular person. The usual sort of progress for ADP is, you know, we have a complaint, we work up the complaint, we file charges, and then they tell us, yeah, I was having trouble then, but I'm not having trouble now. Because obviously, one of the things that we're going to ask for if the person is currently having trouble now is for them to go on inactive status now. And there are other sections of the Business and Professions Code that they can go inactive on if they are having trouble and they can't handle their practice. Now, obviously, in a really, worst case scenario, and we're getting a lot of complaints, we're going to go in there and we're going to try to seize their practice anyway under 6007. But that's sort of a separate and apart from whether or not they are entitled to the alternative disciplinary program as part of a single particular case. Obviously, it's a little cleaner when you're talking about something like a DUI because the person was drinking at that time. That doesn't mean that they're drinking now, and that doesn't mean that they've been drinking since we transmitted their case and while they're going through the program. Lawyers can and always do try to walk a fine line to say, well, I have a problem and I'd like treatment, but I'm okay right now. And we really have to sort of judge that based on the number of complaints that we're getting. You can see when a practice and a lawyer is falling apart, we will be overwhelmed with complaints by their various clients because the lawyer is just not participating in anything. But lawyers can and do fall apart in one or two cases, and then they can still maintain the rest of their practice. And if we're not getting repeated complaints since whatever incident that has occurred, and they're maintaining their practice, especially if they're involved, if they're not solo practitioners and they have other people to rely on, we're not going to go over and take over their practice if we're not seeing a significant number of other complaints, and we're not going to mandate that they go inactive immediately, especially if, as a condition of their participation in ADP, and it's a substance abuse problem, they are abstaining. So in theory, they should be well enough to maintain the rest of their practice because they are actively participating in treatment.
So may I ask a question? I just want to make sure I understand how this all works. The ADP program and the LAP program are linked, and participation in the ADP is supposed to be limited to lawyers who have and admit to substance abuse or mental health conditions. And so part of the condition of remaining in an ADP, and as I understand it, the lawyer and his or her, the respondent and his or her lawyer will negotiate with the Office of Chief Trial Counsel for a lower level of discipline that will be imposed at the end of successful completion of LAP. Is that right?
So yes and no. I think especially because you got the description from Judge Roland, she gets everything after we're all on board together. But the Office of Chief Trial Counsel can and does object to people participating in the program, and we can also argue for a higher level of discipline. What you have to stipulate to are the underlying facts and the culpability, right? They admit, you know, I was retained by this client on such and such a date. I failed to appear at trial. I admit that I failed to perform competently and that I failed to communicate with him and that I failed to return unearned fees. So they admit all that. And I, you know, and I'm not by any stretch of the imagination saying that that's worth, you know, a year, but I'm going to argue that's, you're going to get a year for that, right? I'm just saying this for the purposes of examples. But if you finish ADP, I think you should knock it down to 6 months. And they're going to turn around and say, I think it's worth 30 days if I bomb out of the program, and it's worth a state suspension if I don't. So there, we by no means ever agree on what the actual level of discipline should be. We quite often do disagree, and I submit my level of discipline brief and they submit theirs. So and there will also are those, you know, points in time where I say, you know, this is a disbarment case, and the respondent says this isn't a disbarment case. And if there's no concrete, you know, statute or case law on point, then they may get in even over my objection. So there's definitely points along the way where we disagree and we submit our competing authorities and that sort of thing. But what we have to agree on, lock, stock, and barrel, is a set of facts and the culpability counts.
Okay, what I was trying to get at is ADP, to be an ADP, you have to agree to go into the LAP program and follow its rules and conditions and complete it successfully, right? And what Sharon asked a really interesting question earlier on about recidivism. How many people go into these programs and then come out and then go back in? I'm aware of an audit. I want to say it was about 10 years ago by the Bureau of State Audits of the LAP program, which found, and I don't pretend to remember this exactly, but that the level of successful completions in the LAP program are very, very low. And I'm talking, if I recall this correctly, 13%.
Yeah, I actually remember what you're talking about. I think you're right. I think it was around 2007. Yeah. I think that has been part of the evolution of ADP over time. Again, remember I told you in the beginning, it was a new program. We had launched it, and basically there was not a great set of definition for what the ADP should be limited to, right? And so all of these people who had committed serious offenses or who couldn't actually show a nexus between the conduct that they committed, the misconduct that they committed, and their problem that they said that they had, they were getting into this program, and they were not really candidates because there really wasn't a nexus between the misconduct that they committed and what their problem was, or their actual problem, but it's not something that was amenable to treatment and rehabilitation, which is also the case sometimes. So we had opened the floodgates, and a lot of people were let in. And as we realized that, first of all, we shouldn't be letting just anybody in there. You know, that was one point. We constricted the types of misconduct that could go in there, and then you had to constrict whether or not they can show that proper nexus between their problems and their misconduct. And then you have to look at, you know, whether or not this is the type of, you know, mental health problem that is amenable to treatment and rehabilitation in the type of environment that LAP provides, right? So those three areas were refined over time. And I think that's why, you know, as Judge Roland has said, the program is much more successful now because it's now being offered to and given to people who can succeed in this type of program. Whereas, you know, in the beginning, I think it was just really new and it was in its infancy, and we learned a lot of lessons along the way as to, you know, what types of cases could be successful in ADP.
So it's past 1:30, and again, Danny, I so appreciate your time, especially on your day off. But what I'd like to do quickly is have you all go through what you'd like more information on, or to tee up for the next meeting. Certainly the recidivism data, as I mentioned, there is more recent data than something 10 years ago. And I don't think you're going to find marked improvements in the efficacy of LAP in particular. That's been an ongoing challenge and part of the discussions. I think you're aware of, Julie, about bifurcating the voluntary program off and having it move over to the association, CLA. So that, you know, there's all kinds of issues there. But certainly we can bring forward the recidivism data. I feel like there's much more to discuss on these two topics for our next meeting so that we can reach resolution on the whole, again, that articulated structure of interventions. Would you all agree? Citation, fine, ALD, ADP, to just continue this conversation for our next meeting?
Yeah.
I'm Sharon. Julie?
Yes.
Okay.
Yes.
All right.
And I'm not sure we've completed our discussion of what should be posted on the bar's website, what is public information, those kinds of things. I had mentioned at the last meeting, and somebody, I think it was Julia, said you liked that approach. She said the medical board has two different statutes. One that says what kind of disciplinary information is public information for purposes of the Public Records Act, and a separate statute 2027 that says what needs to be posted on the bar's website. So we might want to look into that further. Those two statutes again are what is public information. And by the way, we're not just talking about disciplinary information here that the medical board dredges up in the course of its disciplinary program. We're talking about things like medical malpractice judgments and settlements that have to be reported by malpractice insurance companies, hospital disciplines that have to be reported by hospitals. So the medical board collects a lot of information from non-medical board entities. And some of that is actually public information. But then the separate statute is 2027 of the Business and Professions Code, which sets forth what the board is required to post on its website. So that might be something we want to look at.
We should definitely dive into that.
All right. Thank you. Thanks again, Danny.
Sure,
Yes.
just let me know if you want me back next time. I'm happy to help.
Okay.
Hey, Leah,
Yes.
just one thing real quick. Who's gonna, tomorrow for the memo, we kind of haven't talked amongst us as to who's gonna be presenting. Do we want to do that just real quick before we jump off?
Sure.
I didn't want it to be me, that's why I was bringing it up. No, I'm.
I'm going to jump off because I have to go back to another working group. So.
Okay, bye, Greg. Whichever, I think two of you doing it, taking the lead makes sense.
I'm willing to help out, but
Another,
want me to lead it and you guys can jump in?
Yeah, great. Thank you.
Doggone it, no.
I mean, we're still in the throes of discussing much of this stuff, right? All
I know, yeah.
outlining that basic flow chart that Linda produced for the.
it's what we didn't get to at the December meeting. And I think those issues are a little separate from what we've been talking about since then. So I think it'll work. Yeah.
Really, the only thing we want, just as I clear tomorrow, really the only thing that we want an answer kind of for them, and I know we're not making decisions still, but the only thing we really want a response from and for there to think about is really just that appeal piece, whether it should be the 3-person hearing panel or the Paraprofessional licensing board, correct?
Yes.
Okay, all right. Okay,
Bye.
Thank you.
thank you.
Thank you.
So,
Bye.